Muslim was affected by this war on terror post 9/11, but there are people who have been subjected to torture, arbitrary detention, rendition, even before 9/11 took place. And our next speaker, Matthew Ryder, he's a barrister from Matrix Chambers. He's going to be speaking about a case that he's working on right now, which basically is a legal challenge of a woman who did say no, who wanted to stand up against this discriminatory system of Schedule 7. And as somebody herself who, as I just mentioned, has been impacted since before 9/11 even began, through her family, has really had enough and decided that a stand has to be taken. So please, Matthew, come up.
Good evening, everybody. Thank you very much for inviting me to speak. I won't speak for very long, and I'm really been asked to talk a little bit about the case that I'm doing that was in the High Court. We haven't had a decision yet. It's the case of Sylvie Begau, and she was prosecuted for failing to comply with the requirements to answer questions under Schedule 7. It's the first significant High Court challenge to the legality of Schedule 7, and one of the things that we are seeking within the case is effectively a declaration of incompatibility with her fundamental rights. In other words, what we're saying is that exceptionally this provision doesn't properly observe the fundamental rights of the people who are affected by it, and as a result the court should make a declaration, what's called a declaration of incompatibility, saying that Schedule 7 is incompatible with people's fundamental rights. There are some complications as to why the court absolutely cannot do that in this case. There are legal technicalities as to why the court can't make that declaration, but the court can give an indication, if it thinks it appropriate, that they would want to make that declaration if they could. And one way or another, it may well be that if we win the case or if we're unsuccessful in the case, it's very likely that the case will go further, either to a higher court or even to the European Court of Human Rights. At the moment, we're one of 3 cases that are moving in relation to Schedule 7 at the moment. And you may think, how is it that it's taken so long? The 2000 Act's been enforced for a very long time. Why is it that it's 13 years later that we're now looking at a challenge to Schedule 7? And there are a number of reasons for that. One of the reasons was that there was a case in Strasbourg, the European Court of Human Rights, back in 1981, that related to a similar provision under which Irish people were detained, and the European Court of Human Rights decided that that was compatible in that particular position with their human rights. And so it seemed for a very long time that challenging Schedule 7 would be very difficult. But to a large extent, things changed last year in a case called Gillen and the UK. And sorry to get into a law lecture here, but Gillen and the UK was a case about some people caught up in a protest who were then subjected to a series of searches under previous provision of the Terrorism Act, random searches that could be made without reasonable grounds for suspicion. And while the British courts held that that was compatible with those people's rights, the European Court of Human Rights found that that provision of the Terrorism Act was incompatible with people's fundamental rights. Section 44 of the Terrorism Act was incompatible with your fundamental rights, and as a result, that provision has been taken off the statute books. It's a very significant decision because what it means is that randomly stopping and searching people is not compatible with their right to a private life and arguably with their right to freedom of against detention and other fundamental rights that they may have. But in particular, with your right to your private life, the right for your possessions to be respected, the right for your privacy to be respected, that isn't properly done when you are stopped randomly. I'm sorry I haven't been here from the very beginning, but I obviously saw some of what Mozam, or heard what some of what Mozam was saying, which of course is very pertinent to the argument. And I'm not sure, it may be that already people have mentioned statistics in relation to Schedule 7, but just to give some kind of idea of the kind of statistics we put before the court. In the period between 2011 and 2012, 63,902 people were stopped in Great Britain under Schedule 7 powers. To put that in some kind of perspective, it was about 600 people in relation to the Irish legislation back in 1981. We're talking about 63,000 people being stopped under Schedule 7. 96% of those people were stopped and detained for less than an hour, but 4% of them were detained for more than an hour. And of those who were detained for more than an hour, 42% defined themselves as white, 27% as Asian, 8% as black, and 18% as Chinese or other. The proportion of Asian people and black people stopped is significantly higher. And when you're looking at people who are then detained, the percentages go up much higher. We are disproportionately represented in those statistics as people who are stopped and detained under Schedule 7. Not only are we disproportionately represented as people who are stopped, people of colour, but also disproportionately represented, more significantly, amongst those who are detained for more than an hour. So it is a hugely significant provision. Tens of thousands of people stopped every year, and disproportionately people of colour, Asian people, black people, and it doesn't take much imagination to realise people who are of a Muslim appearance, whatever that seems to mean, are people who are most likely to be stopped within that, under that provision. So how are we challenging it? Well, what we're doing is we're using the case of Gillen that I mentioned, that case about Section 44, where the European Court of Human Rights said it was incompatible with people's fundamental rights. We're using that to explain to our courts how if the European Court of Human Rights found the other bit of the legislation incompatible with rights, then Schedule 7 should be incompatible with those rights as well. And that's really significant. If that's correct, that would mean that the 63,000 or more stops that happened last year shouldn't have happened. They would be unlawful. They're in breach of those people's rights. And it means that Schedule 7 would have to be considered very carefully to be taken off the statute books. When we're talking about those fundamental rights, though, another fundamental right is engaged in Miss Begal's case. She was coming back from visiting family in France, and she was stopped with her 2 children, one of whom was a baby. Sorry, 3 children, one of whom was a baby, separated from the other 2 children and allowed to stay with her baby. But they wanted to search her, and she wasn't happy to be searched. It was the 3rd time she had been stopped in that way under Schedule 7 in less than a year. She, in those circumstances, she protested and asked why she was being stopped. She was told, any of you who've been stopped under Schedule 7 will know, they tell you, they would usually tell you, we don't suspect you of being a terrorist. And the reason they say that is because they have to say that, because if they suspect you of being a terrorist, they're supposed to arrest you under other provisions, and those provisions would give you greater protection, right to a lawyer and other things. But when they tell you under Schedule 7 that we don't suspect you of being a terrorist, they're searching you under Schedule 7 powers. And that effectively allows police officers or immigration officers to search you, detain you, and require you to answer questions. Ms. Begal wouldn't answer questions. Her concern was that she wanted to have a lawyer present before she answered questions. And you may think that's a perfectly understandable concern when you're being questioned in that situation, because what everybody who's stopped under Schedule 7 is told is that we want to question you, not that we have grounds to suspect that you're a terrorist, but we want to question you to find out if you're someone who's concerned in terrorist acts. Now, you may feel that being held over and detained on the basis that police officers and immigration officers want to question you as to whether you are concerned in terrorist activity seems like you're being, if not accused of something, certainly being investigated about something. And if that's the case, you might want a lawyer. Schedule 7 allows you to speak to a lawyer, but it doesn't, under the codes of practice, require the officers examining you to wait until your lawyer arrives. And so Ms. Begal, after being allowed to pray, was then told she would be questioned without her lawyer being present. And she wasn't prepared for that to happen. She wasn't content for that to happen. And so she said, I'm happy to answer your questions, but not if a lawyer is going to be withheld at the time. In those circumstances, she was asked some questions and she declined to answer them, and she was subsequently charged with an offence under Schedule 7, which at its maximum includes a term of imprisonment. The circumstances were that her lawyer, she had had an opportunity to speak to her lawyer on the phone, and he had told the officers that he would be willing to come to the police station in about 40 minutes, and that in those circumstances, could they please wait? And they declined to do so. And then when he did arrive in 40 minutes' time, he said, well, you were upset that she didn't answer the questions. I'm here now. If you really got something you need to find out, why don't we go through it now? If there is some pressing concern that they had as to why they needed to question her, she's happy to answer the questions now, and there needn't be any problem. And they declined to ask her those questions, but instead decided to prosecute her. And so when it was made clear in the magistrate's court that some of the more complicated legal arguments that we made in the High Court couldn't be considered by the lower court, she was convicted, she pleaded guilty, and she's appealed that conviction to the High Court for that legal principle that I've mentioned to be challenged. So that is where we are with the case. There is another case that's in the European Court of Human Rights at the moment, seeking to challenge Schedule 7. And there is also another case that's about to go through the High Court, seeking to challenge Schedule 7. Legal cases tend to come in a group. Everybody gets the same idea at the same time. And so as a result, there are 3 different cases, and we're all working, understanding what each other's arguments are, working together to make sure their cases effectively cover all the different points in relation to Schedule 7. There's one other thing I'll mention, and again, I'm cautious that it starts to sound like a legal lecture, so I apologize in advance. But what we were really talking about in Ms. Begal's case is challenging Schedule 7 on the basis that it was incompatible with her rights under Article 8 of the European Convention of Human Rights. That is, the right to a private life, the right to have your privacy and your person respected. But she had additional grounds on which she could claim, and these are new grounds that no one has run before. The first ground was Article 6. We said her stop was incompatible, or the use of Schedule 7 was incompatible with Article 6 of her fundamental rights. Well, what's Article 6? Article 6 is your right to a fair trial and a right to a fair process. And we said denying her the right to a lawyer is a denial of her right to a fair process. You may think that would be an uncontroversial proposition, but the difficulty is that with Schedule 7 you can step into a surreal world where, because you're not described as a suspect, you don't get rights that a suspect has, and therefore you don't get the protection of Article 6, the right to a fair process. So in other words, because they've told you you're not a suspect, but they're questioning you as if you're a suspect, you don't have the rights that a suspect has, they say. And you may feel, and we've submitted to the court, that you must look not at what it's described as by the officers, but what's actually happening, what it feels like when you're on the receiving end of it. Do you feel like someone who's being investigated? Do you feel like someone who's being interrogated? And if that's how the process feels when you're being put through it, is it artificial to say you're not really a suspect and therefore shouldn't have those protections? And so we say it is artificial, and it's for the court. The court will decide whether that's a a good argument or not. And finally, we have an argument under her right to freedom of movement. She's a European EU citizen, and as EU citizens, we all have a right to freedom of movement. And the right to freedom of movement can only be curtailed in particular circumstances. Again, this can get pretty technical, and those circumstances must depend on your individual concerns about your individual activity. And we say there was nothing in these circumstances which would merit curtailing her right to freedom of movement, in other words, your right to travel between countries. Before I finish, I should probably say this about Schedule 7. One of the things that's made Schedule 7 very hard to challenge, one of the things that might be very difficult to understand for those of us who are in this room now feeling very unhappy about Schedule 7, is that there is a strand within what Schedule 7 is trying to achieve that is hard to argue against. And that strand is that when someone comes through an airport, there is a process by which you're entitled to ask that person questions about their travel, ask them to produce identification papers, and if necessary, find out the purpose of their travel. We all know that that is a process where if you go to an airport, it would be very difficult to sensibly object to being asked to show that you've got the proper papers that would enable you to travel. I doubt there are many people here who would think it would be perfectly understandable if when they arrived in a country and someone said, show me your passport, you said, no, I'm not going to. We all understand that that's a process that you should go through. And similarly, customs officers have to be able to ask people, what's in your bag? Did you pack the bag yourself? Questions of that kind. I don't think any of us sensibly would object to that. And so that strand of reasonable requirement of you to answer questions has been broadened out into the suggestion that it can go further. Because the real harm of Schedule 7 is not simply that people are being asked questions at airports. The real harm, we would say, is the kind of questions that you can be asked. Because there is no limit on the scope of those questions. Those questions don't have to be connected to why you're traveling. Those questions don't have to be connected to, do you have the right papers? Schedule 7 questions can and frequently do include, what mosque do you pray at? Who were you seeing last week? Is that car your car? How did you pay for that car? How do you pay for your bills? Those don't seem, we say, questions about your travel. How are those questions anything to do with the reasons that you're at an airport? You can't be asked those kind of questions randomly if you walk out of here and a police officer wants to question you. He or she can't ask you those questions and require you to answer them under pain of a criminal offence. You're entitled to say, as every citizen is, thank you, officer, but I'd like not to answer those questions unless you are arresting me. I'd like not to. But somehow when you're in an airport, they've extended the reasonableness of being able to ask you about your travel arrangements into being able to ask you under Schedule 7 about anything at all. And we say it's artificial. One of the reasons it's artificial is this. Supposing police officers want to ask me about who I was seeing in a restaurant a week ago. They know they can't walk into my house and ask me. They know they can't stop me on the street and require me to answer that question. They know they can't arrest me. I haven't done anything wrong, but they want to know. Or they're interested in what kind of faith I have, or what kind of ideology I believe in or don't believe in. They can't ask me those questions. But the minute I step into an airport, not only can they ask me those questions, if I don't answer those questions, I'm committing a criminal offence. And that's why we say Schedule 7 goes too far. Because it's not calibrated on suspicion. It's not calibrated on why you're at the airport. It's not connected to any of those things. It's simply a power that they have to pull anybody over and ask them questions about anything they want. One example, that if you'd been at the court one example we gave is supposing authorities, and let's take a hypothetical country, let's supposing authorities in Kenya decide they don't like somebody who's in Kenya. But they can't question him in Kenya because Kenyan law protects that person from being questioned. So the Kenyan authorities could call up Britain and say, when that guy touches Heathrow, could you ask him this list of questions, please? And if he doesn't answer them, he's committing an offence. And he can't have a lawyer present when he answers them, because we can't question him about that. And we know you can't question him about that if he leaves the airport. But as soon as he touches the airport, all bets are off. Schedule 7 takes over, pull you aside, they don't need suspicion, you can be anybody, and they can say, please answer the questions that we have on this piece of paper. And that's why we say we're perfectly happy for reasonable questions to be required to be answered that's connected to who you are, your travel, and of course, if you're reasonably suspected of committing any kind of offence, then you can be arrested. But the broad powers of Schedule 7, we say, are in breach of your fundamental rights. And that's why we're hoping that the court will agree with us. And if they don't, then we're hoping to pursue it any further.